Hi, good morning. This is attorney Amy Refeca, and I am here for episode 13, Wills on Wednesday. Today I'm going to talk about something, a very common question in our law practice, and a very common question that I see asked out there on the internet, or I like to call it sometimes Google land, where we ask Mr. Google a question looking for an answer. Which I do often as well. But as far as Will's questions, I see this question quite a bit. And that question is if I move to a new state, do I have to get a new will? And so that's what we're going to talk about today. We're going to be here for a few minutes and share just some suggestions when it comes to that question. The really short answer is you may not. You may not need to get an entirely new will. It really depends on the particular state that you moved to and the particular state that you moved from and their requirements for a valid will in that state. It might also depend on whether or not you followed the rules of the state that you lived in when your will was put in place. And so a good example of that, just to kind of share with you an example is, a will in the state of Georgia should be witnessed by two persons and notarized in the presence of, so everyone should be in each other's presence when your will is witnessed, meaning two people have to witness the signature of the person whose will it is. So if it's my will, then there has to be two other people there who watch me sign the will, and then they sign as witnesses, and then there will be a notarization of those signatures. That's the best practice here in the state of Georgia. And the really best practice is to ensure that those two persons who witness the will have nothing to do with the will, meaning they are not interested in the outcome of the will. They won't benefit under the will. A best practice, a really good idea, is to make sure they're not named in the will as maybe the executor, the person who is going to carry out the wishes contained in the will. So bottom line here in Georgia is you really want to have a notary present. You want to have two people that have nothing to do with this will, nothing to do with what is written in the will or named in the will, no role to play in the will. So that's the best practice here in Georgia, and really the best practice to ensure that your will is going to be carried out and heard. Some states have slightly different requirements as it relates to potentially notarizing your will, potentially how many witnesses, potentially whether the witnesses and the notary all need to be present with each other, or potentially whether or not those witnesses should or should not be named in the will. And then if the other state, say, I'm randomly naming a state, I don't know if this particular state has this requirement. If, say, Minnesota has a requirement that's different than Georgia, and then when someone was in Minnesota, not all those requirements were followed for Minnesota, then it could potentially be that if you moved here from Minnesota to the state of Georgia, then your will may not be upheld here in a Georgia court. So there's a lot of ifs, there's a lot of unknowns, I think, is the bottom line when it comes to when you move states. Do you have to get a new will? And I think everyone should really think about the simple question of, do you want to have certainty that your will work when it needs to work? Because your will goes into effect after you pass away, it will be too late to change your will when you need it to work. Simple fact. So what we always recommend is reach out to an estate planning attorney in your local community. set up a time to go in for a consultation and talk to them about, bring your prior estate planning documents, bring your will with you, and talk to them about what your goal and your hope is as it relates to your estate plan when you pass away. Then show them your prior estate planning documents and talk to them about whether that document still works for what your goals are, but also, does the document that you signed previously in the other state, is it going to be upheld here in the state of Georgia? And can that attorney answer that question? And sometimes the question will be answered with, well, we're not going to know until it happens. That's a possibility, but more likely than not, the attorney should be able to say, well, this and this looks good, but there is a potential or a risk here because of this particular reason. So the bottom line is just seek out an attorney in the area where you're moving to, bring your prior estate planning documents to that attorney, talk to that attorney, sit down, talk to them about what you hope your documents do when you pass away, whether that means you hope everything is split equally, whether that means that you hope that a particular person or charity or institution receives all of your money or 50% of your money and things. What do you want your documents to accomplish? And do your current documents, even if they were signed a month ago in another state, do they work here in the state of Georgia? And do they accomplish what your goals are? So that is today's Wills on Wednesday topic. And the bottom line is, it's always a good idea to just see a local attorney in the new state where you live to find out that your documents work. This is attorney Amy Refeca. I'm signing off, episode 13, Wills on Wednesday. Have a wonderful day.